Hello, my dear law learners. So today we are going to discuss about the recent Supreme Court judgment in Ritu chhabaria versus Union of India. So this is one of the landmark case which has been delivered by Supreme Court recently, just few days back. But however, there has been many ramifications of this judgment, and many are urging the Supreme Court and asking the Supreme Court to recall this judgment. Okay, so before going to know what are the what is the judgment given by Supreme Court in Ritu Chhabaria versus Union of India case, first of all, you have to know what is default bail. So unless until you don't know what is default bail, then there is no use of knowing what is Supreme Court's judgment in Ritu Chhabaria versus Union of India case. So the first thing we have to know is what is default bail under section 167 of CRPC. Okay, so this default bail can also be called as statutory bail. Okay, so default bail or statutory bail. So this is under section 167 of CRPC. Okay, so generally under section 167 of section 167 subsection 2A deals with the concept that is called default bail. So the first and foremost thing, if a crime has happened, to set the criminal law in motion, the first thing we have to do is filing an FIR. So if you file an FIR, then only the criminal law will set into motion. So if you want to go further with the case, a criminal case, the first thing you have to do is to file FIR. So after filing FIR, the police will generally start investigation. So after completion of investigation, the police officers will file charge sheet. So this is the third step, filing of charge sheet. Okay, so after filing of charge sheet, the trial will start. Okay, so we all know that according to section 57 of CRPC, so the accused who has been arrested by police officer, he has to submit before the magistrate within 24 hours. So that is section 57 of CRPC. So after he has been submitted to magistrate, the magistrate under section 167 subsection 1, he may authorize for 15 days of remand, that is either police custody or judicial custody. So after that, even beyond that, if the police wants more time for the purpose of investigation, so the default bail concept will be applicable only during the time of investigation. Okay, so under section 167 subsection 2 and A, so the magistrate can authorize for a remand of 90 days or 60 days. That means an accused can be kept in either police custody or in judicial custody for 15 days for vice versa, and simultaneously police custody and next judicial custody and next police custody, like that for up to 90 days or 60 days. So the magistrate can authorize for 90 days of custody during investigation if the punishment for the offense, that means if accused has committed an offense for which the punishment is more than 10 years. For example, I committed a murder. For example, if a person committed a murder, for it the punishment is more than 10 years, we know that life imprisonment, death sentence are etc. So in that case, maximum period that a accused can be kept in custody in the name of investigation will be up to 90 days. Life imprisonment, death. So For example, for any other offenses, that means below 10 years. Below 10 years. For example, if a person committed any other offense for which the punishment is below 10 years, that is, for example, 7 years. A committed an offense, for that offense the punishment is 7 years, then A can be kept under custody in the name of investigation up to 60 days. So that means during investigation by a police officer, magistrate can authorize for custody of the accused up to 90 days in case the punishment for the offense is more than 10 years, in case 60 days, in case the punishment is below 10 years. So I hope this is clear. So if the punishment is more than 10 years, then 90 days of custody can be authorized by the magistrate, and in case the punishment is below 10 years, then the magistrate can authorize 60 days, up to 60 days for custody. So so, for example, if police officer fails to complete the investigation within the set period, A committed an offense for which the punishment is life imprisonment. So, magistrate authorized A for custody up to 90 days. So, within this 90 days, the police officer has to complete investigation. If the police officer is unable to complete the investigation within the set period, then A has every right to ask for default bail. So this is the concept that is called default bail or statutory bail. So that means when the investigation has not been completed by the police officer within the said period of 60 days or 90 days, then the accused person who is in custody can ask for default bail. So this is the concept that is called statutory bail or default bail. Simply remember that when any person is kept in a custody in the name of investigation by police officer, if the police officer fails to complete the investigation within the said period, that is either 60 days or 90 days, according to the punishment of the offense, then the accused has every right to ask for statutory bail or default bail. So this is the concept which you have to understand before knowing what is the Supreme Court judgment in Ritu Chhabaria versus Union of India case. So now coming to the case, Ritu Chhabaria versus Union of India. So as there is a concept of default bail, in order to circumvent this process, many of the investigating officers, they are filing the charge sheet within the prescribed period. That prescribed period is either 60 days for where the punishment for the offense is below 10 years, and 90 days for where the punishment is above 10 years. Okay, so when investigating officers they are doing that, within this period they are filing the charge sheet, but they are filing the incomplete charge sheet. So in order to prevent the accused from taking default bail, this tactic has been involved by the agencies, investigating agencies. That means police officers and other investigating agencies, they are resorting to file an incomplete charge sheet, because the main purpose for filing this incomplete charge sheet is to prevent the accused from getting default bail. So this has been very prevalent in these recent days. So this has been challenged by the petitioner in uh, Ritu Chhabaria versus Union of India case. So in this case, Supreme Court clearly held that in case if any investigating officer, that includes police officer, files a charge sheet within the period that is either 60 days or 90 days, but if it is incomplete, this charge sheet is incomplete, then also the accused has every right to, even if it is incomplete, then the accused has every right to take statutory bail or def default bail. So this has been the judgment delivered by two judge bench of Supreme Court in Ritu Chhabaria versus Union of India case. So this is clear, and this judgment is enabling the accused. So this judgment is in favor of accused. That the judgment clearly is saying that if the investigating agencies files a charge sheet which is incomplete within the period of either 60 days or 90 days, even then also the accused has every right to ask for statutory bail or default bail. As of now, this is very clear. So, basing on this Supreme Court judgment, recently Delhi High Court granted default bail under section 167 of CRPC to accused. So this Delhi High Court judgment is completely basing on the judgment given by Supreme Court in Ritu Chhabaria case. So as usually Delhi High Court also held that, so basing on the Supreme Court judgment, we are saying that you have filed the incomplete charge sheet. So that's why we are granting a default bail to the accused. So after this event happened, then the Chief of Enforcement Directorate has filed a case in Supreme Court and asking the Supreme Court to recall its judgment which was given in Ritu Chhabaria case. So the enforcement agencies and even the center also filed a petition. The central government has also filed a petition, and they are saying that if you give such type of judgments, then it will be very difficult for the investigating agencies to complete the charge sheet and to file a charge sheet. So that's why they are asking the Supreme Court to recall its own judgment in Ritu Chhabaria case. But however, the Supreme Court referred this case to three judgments. In these three judgments, it includes the Honorable Chief Justice of India. So the Supreme Court said that, okay, we can understand you. So because of our judgment, there are so many ramifications. It will be difficult for investigating agencies to complete within the such period of time. So, okay, we will look into the matter, but the Supreme Court never accepted to recall its own judgment. But however, Supreme Court said that instead of recalling our judgment, we will defer our judgment. So there is a difference between recall and defer. So here recalling means completely to take back what the Supreme Court has delivered in the previous judgment. But defer means to stop further. To stop further. Supreme Court said that okay, we will look into the matter until and unless we come up with the further orders or further judgment in these three judgments. Till then, the Ritu Chhabaria case judgment will be kept in hold. No trial court or high court can give any judgment basing upon the judgment given by Supreme Court in Ritu Chhabaria case. So by this, the Supreme Court clearly held that it is not at all going to recall its judgment, but the Supreme Court is going to defer its judgment. So this is regarding the case that is called Ritu Chhabaria versus Union of India and the ramifications of this judgment and consequences. Thank you.